Good afternoon.
Good afternoon, Judge.
I'm gonna call the 1:30 oral argument motion calendar first for announcements. Looks like position 1 was removed, Gardner versus Ward and Roto-Rooter Services. Just want to make sure no one is present for that case. All right. That will be reset to August 6th at 1:30. All right. Okay. Position 2 is Wade versus the Kroger Company and Shamari Spencer.
Good afternoon, Judge. Rob Pickett for Plaintiff Miss Wade.
Good afternoon, Judge. Sim Everett here for Kroger and Mr. Shamari Spencer.
Sam Everett. Okay, good afternoon. This is the defendant's motion for summary judgment. Is defense ready to proceed?
Yes, Your Honor.
And how is the plaintiff ready to proceed?
Yes, Judge, should take 10-15 minutes.
How long do you anticipate this will last, Ms. Everett?
Similar time frame, 15 minutes.
Okay. All right, I'll be with you all in just a moment. Thank you. Position 3, Balora Nicole Lynn versus Reedy Incorporated. Oh, it looks like that was the case where there's the motion to approve minor settlement. And I believe the plaintiff appeared in the courtroom. So I will circle back to that one. All right. On the civil non-jury calendar, I had position 1, Capital One versus Wade Frazier.
Good afternoon, Your Honor. Rohan Rapani here for plaintiff.
Good afternoon.
And Your Honor, we actually, I think we agreed to a joint continuous request with opposing counsel. I believe he was going to be on the call. I'm not sure if he is. I believe we are pretty close to getting this one resolved. If the court is willing to push it out just one time.
Has it been on another calendar?
I don't believe so, Judge. I can double check, but I think this is the first time on.
Okay, it does appear
Judge,
to
I
be the
believe,
first time.
yes, Your Honor.
Okay. Ms. Lawrence, can you hear me?
Yes, I can hear you.
Can you confirm the date for me for the next Zoom calendar? I think it is 1:30 on August 6th.
It's at 10 a.m.
It's at 10 a.m.
Yes.
on August 6th, though.
Yes.
Okay, thank you. All right, Mr. Rapani, this matter will be reset to August 6th at 10 a.m. And you say it's pending settlement?
Yes, Your Honor. I believe we should have an order before the court before then.
Unless you need to push it out to September to be certain that it will be resolved the next time.
Your Honor, if the court would prefer to keep it close, August should be fine. I believe defendant's counsel is just waiting for final confirmation on our last offer.
All right, we'll keep it there. If you don't have anything else, your excuse.
I do have a couple more, Your Honor.
Okay. All right, position 2, Capital One versus Jennifer Hick.
Good morning, Your Honor. Naquisa Simmons for the defendant.
How you doing, Miss Simmons?
Doing well. How about yourself?
Pretty good. Right. Anyone here for the defendant? Oh, proposed consent order file. Did I not sign this already?
Um,
I'm sorry, Miss Simmons, your
not
connection is
to my
bad.
knowledge, Your Honor. I'm sorry. Can you hear me now? It's my understanding that you have
Okay,
not yet
I will get
signed
this
it.
signed today. And you are excused. So if that happens
All right.
again, just give us a gentle nudge. Hey, we submitted a consent order. That way you won't have to appear unless you have something else on the calendar.
Understood. Thank you, Your Honor.
All right, thank you. Position 3 was dismissed, Citibank versus Jason Keller. Position 4, Capital One versus Oluwatoyin Abafimi.
Here for plaintiff on that one, Your Honor. Similar announcement to the last one. We actually have reached settlement terms on this. I believe I just need to get the order to defendant's counsels for review.
Attorney Kyle Witt for the defendant, and plaintiff's counsel is correct in that assessment. We're just waiting for the consent order.
Okay. We can put this on August 6th as well at 10 and wait for that consent judgment.
Thank you, Your Honor.
If you submitted it by then you will not need to appear.
Thank you. That's all my business before the court. May I be excused?
Yes, sir.
Thank you. Have a good day.
You too. Position 5, Capital One versus Jason Pendleton.
Here for plaintiff on that one as well, Your Honor. I believe we have actually already submitted a proposed consent judgment for the court on this.
Okay.
Good afternoon, Your Honor. Kimberly Seymour on behalf of the defendant.
Yes, ma'am. I will, you said proposed consent order, so is it consent order or is it a consent judgment?
Your Honor, I believe it is a consent judgment that we submitted. It was keyed in as a proposed order on the docket, but I do believe it's a consent judgment.
I'm sorry, I'm just trying to pull it up. Okay, I will get that signed today as well. And unless you have something else, Ms. Seymour or Mr. Rupani, you all are excused.
Thank you, Your Honor. That
Thank
is
you,
my
Your
last
Honor.
matter.
Thank you, you both are excused.
Mine also, Your Honor. Take care.
Thank you.
Thank you. All right, thank you.
All right, I had one more matter that I asked to appear. It is for a status conference, Allen versus Anthony Garcia, Continental Divide Insurance, Two Angels Express Incorporated.
William Pay for the plaintiff.
Good afternoon, Your Honor. Deron Bowles on behalf of the defendants.
All of them?
Yes, all defendants, Your Honor.
Okay, good afternoon to you both. All right, okay, I'll place us in a breakout room in just a moment and we can go ahead and get that schedule order done.
Thank you, Your Honor.
Yeah, thank
All
you.
right.
And Your Honor, I can call Darren and we can work on getting a scheduling order filed within the next 24 hours if that would be your preference.
No, I prefer to do it right now.
Okay. All
Okay,
right.
so I will, I'm going to handle your matter first. And then I will hear the motion hearing. And I believe there may be one more, I think the attorney just logged on about the proposed minor settlement.
Yeah.
Okay, I'll circle back with you. It'll only take a few minutes to get that done.
Okay, no problem.
Your Honor.
All right, Mr. Oh, I'm sorry, I don't see your name on your camera, but if you here on behalf of, is it Valora Nicole Lynn? Gentleman with the Pixel 6 Pro. Is my camera frozen?
I think he's frozen.
Okay. I was like, am I frozen?
And it's Attorney Rogers.
Rogers, okay. Okay, maybe he's going out and he'll come back in a second. Did Miss Stokes get that information?
Yes, she has it. I think she's on the way in your office now.
Okay. All right, I'm gonna go ahead and start that breakout room so we can get that scheduling order done, and hopefully Mr. Rogers can get that, get back on. Come in. Mr. Fickett and Miss Everett,
Yes, Judge.
do you all need the court reporter to take down your hearing?
Miss Everett, do you want the court reporter? I- I'm I'm fine. Well, yeah, let's get it taken down. I'll get it taken down.
We'd like it taken down as well, please.
Okay, she will speak to you in just a moment, to let you know how to arrange that. Mr. Rogers, are you back? You're on mute, sir. Can you if
I'm
you're
sorry about
driving,
that.
if you're driving, I can't talk to you, so let me
I'm
know.
actually parked right now.
You say
I'm
you're
parked because
parked?
I am
Okay, I'm
parking
sorry.
at the moment.
Okay. All right.
Thank you.
I'm gonna take a look
Okay.
at this and I'll be back to speak to you about it in just a moment.
That sounds good. Thank you.
Thank you. Mr. Bowles and Mr. Pate, if you'll join the breakout room with me. Mr. Rogers, are you present?
Yes, sir, I'm here.
Okay. Um, good afternoon.
Good afternoon. I apologize. My confusion. I was in based
I'm
on the
sorry?
rule, that I received.
I'm
That I was
sorry.
in your courtroom, and are you not able to hear me?
I can hear you now.
Is that better?
Yes, I can hear you now.
Okay, I'm sorry about that. I was saying that I was actually in your courtroom because the rule nice I received told me to be there. So I went out to the parking lot and now I had to go down the street and get a little better connection. So I apologize for my confusion.
Really? Um, thought that anyway, I thought that we did all of the notices for today for everyone to appear on Zoom. But anyway,
Yeah, Miss Stokes showed me the other printed calendar with that information. So I'm not sure how we missed that, but
okay,
thank you for your patience.
no worries. So on this description of periodic payments, where does who is this money paid to when it's released for Miss Tyler and
It's paid to, and I never can pronounce her name, the minor upon her, the schedule's on there that shows that the payments begin after she reaches the age of 18.
I see. And so that's for both of the minors.
Well, there's only one minor. If
Really?
you've got a couple of minutes, I'd like to put more background. Yeah, the decedent left two daughters behind who were both minors at the time of death. Petronile Tyler has.
He cut out. And we lost them. Non-party claimant, Petronile Tyler.
I'm back. Just got knocked off. I don't know if you can hear me.
I can hear you now.
Okay, so Petronile was a minor at the time of her father's death. She was living in Louisiana with her grandfather, who really couldn't take care of her. She moved to Atlanta to live with her aunt, the decedent's sister, whom I've known from our church for years and years, and that's how we got involved in this. The aunt, was trying to get legal guardianship over Petronile, who goes by the name of Nene, and was not having success with that. Nene turned 18 in November of this past year, meaning she can hire her own lawyer and make decisions.
So I don't need to do anything in regards to her, right? Because I have a settlement agreement and release. I think I lost you.
This is frustrating.
Are you still there?
I'm here. I can see you and hear you.
Okay. All right. So I'll try to talk quickly. I don't need to do anything in regards to Petronile Tyler in this settlement agreement and this paperwork for her, correct?
That is correct.
Okay. So that was really confusing me. All right.
Yeah, and I
So
apologize. We just wanted to show you where all the money was going and that everybody who had an interest had agreed to it.
gotcha. All right. And the date of birth for the minor here, is that somewhere in these documents somewhere? Like, how do I know she will be 18 in the state?
That is a great question. I don't think that appears in those documents. If the court needs some additional documentation, I can get that from her mother, Ms. West.
Okay.
It may
Okay.
be in the complaint.
I was gonna say I'll take a look at the docket. And once I am assured of that, I will sign this and we'll get it e-file. And just so I'm clear, the only thing that I need to sign in e-file is the order. We do not need to sign an e-file, this qualified assignment and release. Is that correct? Did I lose you again? All right. I may have lost him again. I'll get that question answered when he pops back in. Ms. Maynard, do you have everything that you need in order to start the hearing and the motion?
Yes, Judge, I do.
Okay. Ms. Stokes, can you check the docket and the matter with the minor to see if you can locate her date of birth?
Yes.
Okay.
I am back, Judge. I apologize. I think I've got a better now. I'm checking my files. I've got a better. I can give you the date of birth in a second.
Well, I have my staff attorney looking through the docket as well, but I just real quick before I lose you again, the only thing that I need to sign is this order. Is that correct? I do not need to sign anything about the assignment and release. I don't think there's a place for our signature for a judge anyway.
No, we just wanted you to see where the money was going, and
I need to see that.
I do have the date of birth now. It is January 15th of 2016.
Okay. Okay. Yeah, so I'll get this signed and e-file today.
Great. Listen, I appreciate your patience with me, and I appreciate your patience with this case.
Thank you, sir. Thank you.
Thank
I
you.
apologize about the miscommunication. You have a good day.
No, not a worry. Thank you.
You know what? I did not see. I didn't see the attorney fees. That's what I did not say. Oh dear. Maybe it's here. I'll take a look at this in a second. I'm gonna go ahead and take care of this other matter. I'm sorry, Miss Maynard, did you say that you were ready?
Yes, Judge.
Okay. All right. Mr. Pickett and Miss Everett, you're ready as well?
Yes, Judge. Thank you.
Yes, Your Honor.
All right. This is the matter of Janice Wade versus the Kroger Company and Shamari Spencer, case number 2025 CV 01900. This is the defendant's motion for summary judgment. The plaintiff is represented by Mr. Robert Fickett. The defendants are represented by Miss Sim Everett. All right. Miss Everett, you may proceed with your motion.
Thank you, Your Honor, and good afternoon. Thank you so much for taking time to listen to our arguments today. I'm here for defendants Kroger and Shamari Spencer, and I'm filling in for attorneys Regina Taylor and Sarah Lyle today. I understand that you've read through our briefing on this one, but I always like to ask, would you prefer that I just jump into my argument, or do you have any specific questions that you'd like me to address first?
I have been out the entire month of June on vacation, and I have not read your brief. So I will read your brief, but if you can just kind of give me a summary of, I'm assuming just from the case that this is some sort of premises liability matter?
Yes, you're
Okay.
correct.
Yeah. Just give me a summary of that, and then you can jump into your argument.
Sure. So this is premises liability slip and fall claim. It happened back on December 23rd, 2024. Plaintiff is claiming that she slipped and fell on water. She's claiming she sustained personal injuries. Our motion here today is specific to the manager. So Mr. Spencer was named in this lawsuit. So yeah, I mean, that's the general context here. Our briefing does get into this maybe in more depth, but Your Honor, this motion, it's really about plaintiff's choice to sue our manager here, Mrs. Shumari Spencer. He was not even at the Kroger grocery store on the day when this incident happened. He's just a manager of the store. Per the statute, he's not an owner, he's not an occupier, and honestly, he can't be personally sued for a slip and fall incident that happened at a grocery store, especially on a day when he was not there.
I remember this now.
Okay.
Mm-hmm.
All right. I will just get into it.
Okay.
Like I said, Mr. Spencer is just a manager at the store. The facts, which are supported by evidence of the record, they're very straightforward. This is a very simple case. Our undisputed evidence shows Mr. Spencer had no ownership interest in the store. He didn't have a superior right of possession to the store. Kroger created all the policies and procedures for the operation of the store. Mr. Spencer, he never operated the store outside of the scope of these policies and procedures. He was very limited in that way. And like I've said, Mr. Spencer was not even at the store at the time of this incident. Last year, Judge Eddie Barker from Douglas County State Court, he reviewed an identical situation, and he actually granted summary judgment, effectively dismissing a Kroger store leader who he found that she was acting entirely within the course and scope of her employment, and she was also not present at the store at the time. I'm going to tender that order as an exhibit, which I found to be quite persuasive. I'm going to tender it as Defendant's Exhibit 1. Is there a specific procedure that we need to follow to enter that over Zoom? I can just send it over after we're done here so that everyone has it. I think that might be,
Yeah, if you can email it to the court reporter, if you'll get, I don't know if you already have her email address, it may already be on there.
okay.
And she can make it a record in the case. Is there any objection to the exhibit from Mr. Fickett?
No, Judge, that's fine.
Okay.
Okay. So I will go ahead and do that after we get done here.
Okay.
Judge Barker dismissed that manager. He found that she was acting within the course and scope of her employment, and she wasn't there. Plaintiff cannot dispute the evidence shows Mr. Spencer was not there. Plaintiff can't dispute that the evidence shows that Mr. Spencer was not an owner or occupier of the property, and plaintiff can't dispute that Mr. Spencer performed no affirmative act of negligence. Therefore, Mr. Spencer cannot be held liable, and plaintiff's claims against him should be dismissed. So, to the first point, Mr. Spencer is not an owner or occupier. Plaintiff has decidedly failed to meet her burden. She has to point to specific evidence, not her own speculations. And here, all she's relying on are those speculations. She points to her own complaint in support of her allegations, but that's not evidence. She has put forth no evidence to show that Mr. Spencer is an owner or occupier. What the evidence does show is that Mr. Spencer is a manager with managerial duties. And those duties are dictated and laid out by Kroger. Mr. Spencer's testimony and his affidavit both confirm that he was trained by Kroger on Kroger's policies and procedures to operate the store, and his job is to follow Kroger's training and Kroger's policies and procedures to ensure that the store is functioning according to Kroger's standards. That deposition testimony and that affidavit, very clear. Mr. Spencer did not own the store. He was only operating that store according to Kroger's policies and procedures. In her briefing, plaintiff makes some baseless allegations and legal conclusions about Mr. Spencer's role as a manager, but those are just allegations. There is no evidentiary support for those claims, and she cites to no evidence to support those allegations and those conclusions. Instead, like I said, she's citing to her own complaint, but there's no evidentiary support. She even cites to Mr. Spencer's deposition testimony, but that testimony, if you read through it, it's confirming that he's following Kroger's training and Kroger's standards when he's overseeing the operation of the store. The court in Shear v. Cliot, and the citation for that is 133 Georgia Appellate Court 702 in 1975. That court described the many factors that must be considered when establishing control over a premises. Mr. Spencer's affidavit and his testimony address all of these factors that the court discusses in Shear. And the evidence definitively establishes that Mr. Spencer did not exercise sufficient control over the premises such that he is an owner or occupier. Just going through those factors, the evidence shows Mr. Spencer did not hire or fire employees. The evidence shows he didn't set employee wages. He didn't pay those employees' wages. He didn't have a right to exclude customers. He was not responsible for maintaining and repairing the premises. He never paid any taxes or bills for the store. And he didn't assume any specific lease obligations for the store. Your Honor, it's very simple. Mr. Spencer did not own the store. He didn't create any policies or procedures for the operation of the store. That includes the fact that he did not create policies and procedures relating to safety or training. Mr. Spencer was simply responsible only for enforcing or effectuating Kroger's corporate policies and procedures. I also want to bring to your attention, Your Honor, a case cited by plaintiff, and that's the Gregory v. Trupp case. And plaintiff argues that this case is a binding authority that supports her position. But there is a very distinct difference in the Trupp case. In Trupp, the individual that was directly sued owned the property, and that individual had maintenance duties for that property. Clearly, that is not the case here. That case cannot be binding here. Here, Mr. Spencer works for Kroger. Mr. Spencer was trained by Kroger. He's subject to Kroger policy, and he cannot act in a manner outside of Kroger's policy and Kroger's training. Mr. Spencer has no maintenance duties or obligations for the store. Mr. Spencer clearly is not an owner or occupier as defined by the law and even the standards in Trupp. All of the evidence of record shows that as a manager, Mr. Spencer's job meets none of the factors required to show that he had sufficient control over the premises. He had no superior right of possession over the property. He didn't hire employees. He did not set wages. He wasn't setting hours. He created no policies and procedures. None of it. We also have to consider a fact that we can all agree on here. Mr. Spencer was not even at the store at the time of the incident. In fact, not even plaintiff makes any affirmative allegation of negligence against Mr. Spencer that falls outside of this course and scope of his employment, and there is no evidence that Mr. Spencer was negligent. Plaintiff, she cannot point to any specific actions that show Mr. Spencer was individually negligent because he was not there. Georgia law is very clear. An individual with supervisory control may be liable, but only when that individual was individually negligent. So in short, that person has to be there and that person has to do something specific to be liable. It's quite simple. Mr. Spencer was not there. He could not have done anything to cause that incident because he just wasn't there. So summary judgment as to plaintiff's claims against Mr. Spencer is proper. And Your Honor, I want to remind you about Judge Barker's order granting summary judgment for that manager. The situation that Judge Barker reviewed is identical to this one. The manager that was dismissed in that case and Mr. Spencer, they were both not at the store at the time of the incident. They were both employed by Kroger in the same job position with the same training and with the same duties. They were both required to follow Kroger's policies and procedures to operate the store according to Kroger's standards. And in both those situations, plaintiff asserted no allegation of affirmative acts of negligence against the managers. Judge Barker, he reviewed deposition testimony and an affidavit, just like the evidence that has been presented to you, Judge. And Judge Barker concluded that manager should be dismissed. Your Honor, we've shown you that Mr. Spencer is not liable because he wasn't an owner or occupier, and he wasn't liable because he was not individually negligent. The standard is clear. An employee who's simply performing his duties, implementing corporate policies that he didn't create, is not liable just because an incident happens. I have some more cases. Beasley v. A Better Gas Co., and that citation is 269 Georgia Appellate 426, 2004. And Dempsey v. Southeastern Industrial Contracting Company, 309 Georgia Appellate 140, 2011. Those are courts that agreed an employee who is just performing their duties cannot be held liable just because something happens. There has to be an individual act of negligence. Mr. Spencer, he was just an employee. He was doing his job. He was following Kroger's policies and procedures when he was at the store. But as we know, on the day of this incident, he was not even there. Your Honor, there is just no evidence to support a genuine question of material fact as to Mr. Spencer's lack of ownership over the property, his lack of control over the property, and his total lack of involvement in this incident. Therefore, summary judgment as to his claims must be granted. Do you have any questions for me, Judge, at this time?
No, ma'am. Thank you.
Thank you.
Mr. Fickett.
Thank you, Judge. I don't always, as a matter of course, request oral arguments on motions, but I did just because I wanted to point out the misstatement of some law that is in the defense's motion and was kind of restated today. There's a lot of he didn't create the policies, his only job was enforcing it, he wasn't there. That doesn't matter. The law is clear that a store manager can be held liable under premises liability theory. The statute itself has a provision for an occupier. No one is arguing that Mr. Spencer is an owner of the Kroger. That's not a part of this at all. But when you read my response to the motion, Judge, I lay out the cases that support my position on this, which is, I think, going to be very clear on what the law is at this time. I love being in front of Judge Barker. I don't know what his ruling was or what that case was about. If it was that ruling on this case, I think it would be the wrong ruling. But the authority is if you have the law is if you have sufficient control and authority over a premises, whether that's implementing, supervising, ensuring compliance with policies, you can be held liable under a premises liability theory. The main case that I cite in my brief is the Gregory v. Truck case. And in that case, he is more or less a maintenance guy that comes on the property every now and then to mow the grass for $250 a year. And he clears out some trash, called the cops on some kids sometime, and one of the occupants one of the invitees walks across the grass, steps in a hole, gets injured. The trial court granted the motion for summary judgment that he wasn't an occupier of that premises. The Court of Appeals then reversed that decision, saying, no, there's sufficient evidence that he had control and authority over this property that he can be held liable, or that a jury can find that there's sufficient evidence that he's liable. Because I'm not asking, Judge, for you to disclose of this as a finality. This is something that I think the jury would determine later on when they hear the testimony and the evidence of Mr. Spencer's control as the head store manager of this property. The main case that is cited by the defense, and really all defense attorneys kind of cite to this Adams v. Sears Roebuck case. It's used for removals. It's used for trying to say that managers can't be held liable as a matter of law under premises liability theory. The Adams case is very, very specific to the facts of that case, which we don't know because the appeals court didn't write hardly anything in their opinion in that one. And so all the subsequent cases after that address the arguments of, oh, Adams says a manager can't be held liable under the theory of premises liability. The main things that I cite are federal cases because that's where it's litigated most often. It's when it's removed to federal court, and then they're litigating whether or not there can be a valid claim brought against the store manager. And so there's tons of federal court cases that go back and they interpret the Georgia cases that the defense is relying on. So we have OT versus AMC. That's one where he's a manager of an AMC movie theater that's included in the case personally. And they found that there's a certain level of supervisory control that can create liability. And they specifically address the Adams case and saying that in that case, the court didn't evince any intention to overrule or abandon the earlier line of cases, recognizing the general rule that liability under 5131 may extend to non-owners with sufficient supervisory control over a premises. All of these cases are the two main ones cited in the defense's brief, Adams and Anderson, are both incredibly limited in their scope. And every subsequent case that cites to those addresses that, saying, well, those are very fact specific to those judges that were listening to the facts in front of them. One, there was no controversy, the defense submitted an affidavit saying I have no control or supervisory role over this. The plaintiff didn't even argue against it. So that was an easy decision saying, yeah, there is nothing, there's no uncontroverted testimony in here. We have that in our case. We've done depositions. He's the store manager. He has the ability to set schedules, implement or to ensure compliance with the safety policies and procedures that are in place, the lack of which led to Miss Wade getting hurt. That's our whole premises liability claim. And so when you go through, the main thing that I would ask judges, just if you look at the cases that I cite to, I'm very intentional when I do cite to cases and the ones that I think are directly on point. And the OT case, the Martin case, which is also one where manager of an apartment complex, Acosta, manager of a Chili's, all these cases talk about Georgia substantive law on store managers and how a viable premise liability claim can be brought against them when the plaintiff shows that they have some sort of control over compliance with policies and procedures. And kind of one of the big other cases on here is the Poll versus Deli Management. It's also a federal court case from 2007, but it's cited in a vast majority of the subsequent cases. And it goes through the different situations where people are deemed to be occupiers of a premises where it was sufficient to hold them accountable under premises liability theory. Specifically, it talks about how a person in charge of the premises, an individual responsible for ensuring compliance with any sort of regulations, inspections, maintaining the premises, people that inspect, maintain, or repair the premises on behalf of the owner. These are all situations that are directly what we have here. I mean, this isn't even just like the deli manager or something. It's the head store manager. He's in charge of the whole store. There's been significant talk about, and I noticed this in the brief. I don't like when the law is completely misstated, and I think that on page 7 of defense's brief, they say in bold, an individual cannot be held liable under principles of premises liability where she was not present at the location at the time of the injuring incident unless she happens to own the premises. That is not the law. I don't know where that comes from, but that is a misstatement of the law, and I just wanted to make sure that that's not the standard that we're deciding is this guy an owner of the store? That's not what we have to show. We have to show that he has some sort of supervisory authority here. So the deposition transcripts, which have been submitted to the court, they're also attached as exhibits for the relevant portions. This isn't just a case where no one's done anything yet and they're filing a motion to dismiss. We actually have sworn testimony that he was the manager, that he was in charge of policies and procedures being implemented, enforced, inspections being done. So if Your Honor has any questions for me specifically about any cases or distinguishing anything from the defense, I think the case law is going to be very clear from my brief on whether or not a store manager can be held liable under a premises liability theory. And I think the decision for Your Honor isn't whether they can be held liable. It's, did I do enough to show that this particular store manager had sufficient control over the premises? And I think that's a determination for the jury when they hear his testimony on his job, his role, his experience there, his duties, his training. And I think that's a jury determination, but at the same time, there is no bright line. A manager cannot be held liable unless they're there, or I don't know where that came from. And I don't think that's a proper statement of the law.
Okay.
But if you have any questions for me, Judge, I'm happy to answer them all. I've done a lot of research and trainings and talks on manager liability for being occupiers. So,
Okay. I understand your argument. I don't have any questions. So I'm going to take a look at the case law. I do want to give Ms. Everett closing on her motion. If you don't have anything else, Mr. Fickett.
no, Judge, that's all I wanted.
Thank you, Ms. Everett.
Very briefly, Your Honor, I know you're going to take time going through the cases. I just want to bring to your attention that plaintiff is citing to cases where the procedural posture is different. So those are motions to dismiss. And as I'm sure you're aware, the standard is different for motion to dismiss. At that point, the court's looking at plaintiff's complaint. But here we're at a motion for summary judgment. So we need to be looking at the evidence. We have facts. We have other things we can point to. We can't rely on just plaintiff's allegations. I think I mentioned the Beasley and Dempsey case. There is the Nix v. Walmart stores case, which I believe we cited in our briefing as well. And Shear v. Cleot is another one that I mentioned today. But ultimately, the standard is clear. If you read through the cases, you'll see that even the cases plaintiff cites to has those exceptions to the rule. And here we are in one of those situations. Mr. Spencer did not own the store. He didn't exercise sufficient control over the store, and he wasn't even there. There is no evidence to show that he performed any specific act that would result in him being individually negligent. Thank you, Your Honor. That's all I have.
Judge, can I just clarify something
She
real
gets
quick?
last minute,
Okay.
word
It's
on
okay.
her motion. So if you say something, she's going to get the last word.
Yeah, I just wanted to be clear that we're not alleging something. This isn't about a specific act that he did. It's his role as the manager and his general role of implementing all these things. So I'm if there is a law on it that we have to prove that he did a specific act to be held liable, I'm not familiar with it. But if there's cases on that, I'd love to take a look at those.
Okay. Ms. Everett, anything else?
Not at this time, Judge.
Okay. Thank you all. We'll take a look and we'll issue an order this month.
Judge,
By
would
the
you
end of
like
this week.
would you like us to submit proposed orders?
You can if you like. Typically though, in matters like this, I usually draft my own,
Okay.
but you can certainly if you like.
All right. Thank
Thank
you,
you.
Judge. Appreciate your time today.
Thank you, Your Honor.
Thank you. Ms. Mann, did you need to speak to them any further? Okay, she already told me that. You don't need to speak to them. Okay.
I do, Miss Everett. Did you get my email address from the picture there that you can see? So you can
Yes.
send me that. Okay, perfect. That's my only question, Judge.
Okay. There's someone on named Kyle Wahab. Did I skip
He's with
someone?
me, Judge.
He's
He's
with
my
you.
associate,
Okay.
yeah.
All right, very well.